Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Last night we had a bunch of documents dropped onto the docket in the Justin Baldoni versus Blake Lively case. Most of them are attached to the motion to compel filed by Blake Lively in order to try to obtain certain information from the Wayfair parties and Wayfair third parties. But the really interesting stuff is not in these requests. It's in the emails between counsel where we can see them fighting back and forth about this Van Zandt lawsuit regarding the discovery. Regarding these requests for production sent to the Wayfair parties and Wayfair third parties, they're mostly trying to get financial information. In this letter to the judge, Blake Lively's counsel writes, even though the deadlines for compliance passed weeks ago, neither Wayfair nor the Wayfair third parties represented by Wayfair's counsel, have produced a single document. The court should intervene now and put an end to Wayfair's improper attempt to prolong third-party discovery. The Wayfair third parties are each current or former Wayfair executives and employees who are likely to possess documents and communications relevant to the claims and defenses in this action. Here they're saying Ms. Lively agreed to deadline extensions for each of them for the compliance, and though those deadlines have passed, they haven't given them anything. Instead, after extensive conferrals, during which Wayfair counsel walked away from numerous objections and agreed to produce all relevant non-privileged material in response to the subpoenas, Wayfair counsel confirmed that Wayfair had taken responsibility for and intended to produce responsive and non-privileged professional materials collected from its own repositories on behalf of the affiliated third parties. Wayfair and the Wayfair third parties gambit improperly seeks to extend the third party's deadline for compliance. This is a letter written by Summer Benson, an attorney for Wayfair, and it was sent 2 days ago on May 8th to Blake Lively's attorneys. Counsel, we strongly disagree with the self-serving characterizations in your email. Nonetheless, we reiterate that our clients have complied, and will continue to comply, with all of their discovery obligations. As we made clear during our call, we are fulfilling all requirements under both the federal rules of civil procedure and the local rules. To be clear, as expressly communicated, we are actively collecting materials from all relevant sources, including Wayfair's servers and databases, as well as personal devices where applicable. As also discussed on our call, the collection process is well underway, and we expect to begin a rolling production by the end of this month. Your attempt to distort the record to suggest otherwise is not constructive. Notably, as during our call, you have cited no authority supporting your assertion that you are entitled to detailed information about our collection process. Separately, and as previously confirmed, Wayfair as a party is collecting all professional materials from the subpoenaed third parties in connection with their compliance with the Rule 45 subpoenas. This was another letter to the judge written yesterday regarding these issues. Blake Lively's counsel is saying that Wayfair refuses to divulge even the most basic information relating to their collection efforts, which apparently are still underway, and have left Ms. Lively completely in the dark with respect to what documents and information may be in their possession. But the Wayfair parties are not permitted to hide the ball like this, and they do not get to choose what documents are and are not relevant to their own $400 million damages claim. Here, the attorney for Blake Lively is giving some background as to why they feel they need this financial information, being a little bit of a turd about it, and saying that Wayfair has alleged some unclear financial loss related to the film, but refused to produce the requested documents bearing on that loss. I feel like we're leaving out a lot of stuff, including that these lost profits are not just related to the film It Ends With Us, but also losses related to lost opportunities and lost projects because of Blake Lively's false allegations. For example, the Pac-Man movie that Wayfair had apparently been developing since 2022 may no longer be happening. According to Ezra Hudson, simply put, the law does not permit what the Wayfair parties seek to do here: claim financial harm, but then refuse to turn over specifically requested financial records in favor of some unstated alternative set of documents they subjectively deem sufficient to demonstrate damages. Ms. Lively is entitled to receive all relevant financial information to disprove the Wayfair parties' damages and expose their lawsuit and its frivolity. I feel like they were arguing back and forth about what should or should not be produced, and now that that's been decided on and they've gone back and forth, they're saying that they're working on getting that information to them, and then Lively's side is just saying they're refusing. So I don't get it. I don't really see what the problem is, unless the problem is that it's just not timely. But if they were arguing over the scope of this stuff and just agreed to it, would they not then need more time to produce that information? We're going to need to ask Omar or someone else about the rules here, because this is getting a little confusing to me. And this is where the responses and objections to those requests for production, the requests for productions were available in the document we just went through. But this is each of the Wayfair parties' responses to those requests, and they are under seal, so we can't see them right now. And thank God for small miracles, because I am very tired. These emails from counsel are just showing where they were scheduling meet and confer. Most of the interesting stuff is in this email from Kevin Fritz, one of the lawyers for the Wayfair parties, that sent to Matt Bruno, one of the attorneys for Blake Lively. So this is a summary of their meet and confer, and then the red text here is Kevin Fritz's responses. So let's go over what Kevin Fritz wrote here. Your recitation of the conversation is incorrect and incomplete. When asked to explain the relevancy of categories of documents sought by these requests, you replied, damages. You failed to explain because you cannot explain how documents concerning net worth or liquidation of assets are relevant to the damages incurred by the Wayfarer parties. Furthermore, I advised you that the Wayfarer parties will produce non-privileged documents concerning their damages. I further advised you that if upon receiving such documents you believe that additional documents should be produced, you should notify us of that position. You agreed that was an acceptable manner of proceeding. Here's what I found to be one of the more controversial parts of this letter. Blake Lively's attorney wrote, the Wayfarer parties object to request number 60 propounded upon Mr. Baldoni and will not search for or produce documents or information responsive to this request. Request number 60 seeks information regarding Mr. Baldoni's asserted neurodivergent conditions, which he admits he has communicated about in connection with Ms. Lively's allegations and has relied on to explain his alleged sexual harassment, retaliation, other inappropriate behavior on the set of It Ends With Us. This information is demonstrably relevant to Ms. Lively's claims, including but not limited to her claims of sexual harassment and retaliation in violation of Title VII, and the Wayfarer party's argument otherwise, without support, does not relieve them of their obligation to produce responsive, non-privileged documents. It is also relevant to Mr. Baldoni's alleged conduct in influencing the public narrative regarding his conduct on the set of the film at her expense. I found the contents of this paragraph to be a little bit upsetting, and I find it a little bit frustrating, and I need a break from that, so I will go over my feelings on this issue at some time soon, but for now I'm just going to go through the rest of the letter. Your recitation of the conversation is incorrect and incomplete. When asked to explain the relevancy of the health-related documents sought by request number 60, you replied, it's in the discovery. I then asked you to what discovery you were referring, and at that point you realized that 1, no discovery has been exchanged between the parties in this action, and 2, you should not have referred to the discovery that your firm obtained through the New York State Court action in which, from our viewpoint, you purposely omitted Lively as the plaintiff and listed her company Van Zandt as the plaintiff, and purposely omitted one or more of the Wayfarer parties as defendants so that A, no one would know that Lively had, in essence, commenced a lawsuit, and B, the Wayfarer parties would not receive notice that Van Zandt, i.e. Lively, had served a subpoena. In an effort to retreat from your reference to such discovery, your colleague Michaela then referred to Lively's allegations on page 60 of her amended complaint. However, paragraph 188 of page 60, which you cite above, purports to quote from a text message that appears to have been obtained by your firm in response to the Van Zandt subpoena. In other words, both you and Michaela were referring to the same discovery that you obtained without notice to the Wayfarer parties. If your firm wants to explain to the court how your firm obtained information concerning Baldoni's purported medical condition and attempted to explain how it is relevant to Lively's claims, we welcome the opportunity to respond thereto. So it seems pretty clear we're just seeing the beginning of the back and forth over this Van Zandt stuff. It was brought up last night in a letter to the judge regarding Stephanie Jones' attempt to prohibit the Wayfarer parties from enforcing a subpoena against Edgeworth Security. I'll link to the video about that below. But this is the first time we're really seeing the attorneys go back and forth about this. Of course, this has all been happening behind the scenes where we can't normally see this stuff, but since this was attached as an exhibit to something else, we were able to go over that. Like I said, the responses from the Wayfarer parties to the requests for production are remaining under seal for now. If they end up unsealing those documents, I'll take a look at them. But this is all I got for right now. So thanks for watching, and I will see you all soon.